I want to welcome those of you who are in our audience today to this very important forum where we will be discussing the new Texas law that has gone into effect, signed into law by Governor Abbott, and that has not been intervened against by the United States Supreme Court, SB 8, a law that bans abortion after 6 weeks of pregnancy, that provides no exception for instances of rape or incest, and that deputizes Texas citizens to be able to bring lawsuits against individuals who aid and abet those who are seeking to terminate a pregnancy. I am Michelle Bratcher Goodwin, a Chancellor's Professor at the University of California, Irvine, and the founding director of the Center for Biotechnology and Global Health Policy. We're happy to bring this program to you today, and I'm going to turn it over to our moderator, Tanya Acker.
Thank you, Professor Goodwin. Thank you all for joining us. We've got an incredible panel, so I'm going to turn right to introducing them so we can get into what will certainly be a very important conversation. Our first panelist is Professor Mary Ziegler. She's the Stearns Weaver Miller Professor at Florida State University College of Law. She specializes in the legal history of reproduction, the family, sexuality, and the Constitution. She's the author of After Roe, The Lost History of the Abortion Debate, which won the 2014 Harvard University Press Thomas J. Wilson Memorial Prize for the best first manuscript published by the press in any discipline. She's also the author of Beyond Abortion, Roe v. Wade and the Fight for Privacy. Her most recent book, Abortion and the Law in America, A Legal History, Roe v. Wade to the Present, was published by Cambridge University Press last year. She's a member of the board of directors of the American Society for Legal History and a recipient of the Transformation Through Teaching and Florida State University Teaching Awards. Welcome, Professor Ziegler. Professor Lisa Ikemoto is the Martin Luther King Jr. Professor of Law at UC Davis School of Law. She teaches bioethics, healthcare law, public health law, reproductive rights law and policy, and marital property at UC Davis School of Law. Her research areas include reproductive rights and justice, healthcare disparities, and science, technology, and law. And she has a specific focus on the manner in which disparities impact access to biomedical technology use and to healthcare. She has faculty affiliations with the Aoki Center for Race and Nation Studies, the Health System Bioethics Program, the Feminist Research Institute, and the Religious Studies Department. Welcome, Professor Ikemoto. You've all met Professor Goodwin, but here again, Professor Michelle Bratcher Goodwin is the Chancellor's Professor of Law at UC Irvine School of Law, and she's also the Director of the Center for Biotechnology and Global Health Policy. She's the recipient of the 2020-2021 Distinguished Senior Faculty Award for Research, the highest honor given by the University of California, and she's the first law professor at UC Irvine to receive that award. Credited with helping to establish and shape the health law field, Professor Goodwin directed the first ABA accredited health law program in the nation, and she also established the first law center focused on race and bioethics. Her books include Policing the Womb, Invisible Women and the Criminalization of Motherhood, Biotechnology, Bioethics and the Law, Baby Markets, Money and the Politics of Creating Families, and Black Markets, the supply and demand of body parts. Welcome, Professor Goodwin, and thank you for having us. Finally, Dr. Tabitha Harkin is a professor and the division director of family planning in the OBGYN department at UC Irvine. She trains UCI residents in family planning, and since 2009, Dr. Harkin has directed the UCI Ryan Residency Training Program in abortion and contraception. She created the UCI Division of Family Planning, which has become a referral center for high-risk family planning patients for all of Orange and San Bernardino counties. She also continues to provide direct clinical care, to advocate for the sexual and reproductive rights of all people, and to continue to teach residents and students. Thank you, Dr. Harkin. Before we open it up to conversation, I thought I'd first turn to each of our panelists, perhaps to provide a little context about where we are right now. It's a bit of a disorienting environment. Why don't we start with you, Professor Ziegler? You can put some of this in historical context. It's not a new fight that we've been having.
Right. So for the past several decades, generally the fight has been about whether Roe v. Wade will be overturned, right? That seems to be the fixation. And most of the legislation we've seen has been laws designed to create a perfect test case to reverse Roe, whether that's focusing on viability as the point at which you can ban abortions, or on claims that abortion is in fact dangerous for pregnant people and women. I think what Texas reflects is that that movement has never been fully satisfying to people who are the most opposed to abortion, who in the past were the people blockading abortion clinics, the people who at times were breaking the law, and of course, at times committing acts of violence against people who worked at abortion clinics. These people now define themselves as abolitionists and see incremental abortion legislation as bad, right? They won't refer to themselves as pro-life because they see that as being too soft. And so what emerged in Texas was an effort to appeal to those people and still have your cake and eat it too, right? And get a Supreme Court decision that's favorable. It emerged from the so-called Sanctuary City for Life movement, which is a play, of course, on sanctuary cities for immigrants. And the argument was, you don't need to wait to ban abortion. You can ban it right now, as long as you have private citizens doing the enforcing. The virtue of that not only is that you are allowed to get away with it, it's also that you can enforce a law, which is, of course, very difficult to do in a world where you can get abortion medication on the internet or drive out of state to get an abortion. And the beauty of it is that it's resistant to democratic change. Because then if in a state like Texas that's becoming bluer, you have prosecutors who are not willing to enforce like a law like SB 8, it doesn't matter anymore because you have private citizens and deeply red communities who are willing to do so. The backstory of SB 8, like much of abortion restrictions, is not a story just about abortion. It's also a story about LGBTIQ rights. One of the models for SB 8 was the so-called Save Chick-fil-A bill, which emerged because San Antonio was planning to exclude Chick-fil-A from its list of airport vendors because Chick-fil-A has a history of donating to groups that discriminate against LGBTIQ people. Texas lawmakers again devised a bill that said, if you suspect that you are being discriminated against because of your religious beliefs, if you're a conservative Christian, or your donations, that you can bring a civil suit and you can get an injunction and you can get attorney's fees. So again, this civil enforcement mechanism has emerged across the spectrum as a way of having an end run around the Supreme Court, but also a way potentially of harnessing the movement's extremist wing to be a kind of private enforcement mechanism for the state rather than a thorn in the state's side as it seeks to reverse Roe, and a way potentially of actually enforcing an abortion ban, which otherwise seems like an impossible task. So I will leave the history there and let other people explore some of the other important questions this raises.
Thank you. Professor Ikemoto.
Sure, I'm actually not going to talk about the specifics of Texas SB 8, and I'm going to sort of do a very quick and broad brush sort of intersectionality analysis, talk about sort of who's disproportionately impacted by this range of laws, not just this particular one. So of course, pregnant people take the direct impact of any of these abortion restrictions, but it's people of color in particular who are disproportionately affected. So for example, many of the media stories have highlighted the fact that Black women use abortion services at the highest rate. In Texas, when the law that was at issue in Whole Women's Health went into effect, that of course resulted in clinic closures. The rate of abortion dropped substantially in the state at that time within a very short period of time. And it was primarily Hispanic women and Latinx who were primarily and disproportionately affected more than any other racial and ethnic group in that state. It's also important to keep in mind Native women, Indigenous people. Most Native women seek health care through Indian Health Services, but federal laws ban federal funding for abortion services. And so for those people who can only seek services through Indian Health Services, they don't have access to abortion. And many Native women live in states with the most restrictive abortion laws. And so for those who can seek services outside of the Indian Health Services clinics, they are in states that have faced the highest percentage of clinic closures. So they still don't have access as a result. And then I think it's also important when we're talking about this to think about also the barriers to access for contraception. When the ACA was enacted, abortion rates dropped. And one of the primary reasons for that was that access to contraception was increased by the Affordable Care Act, or the ACA. Excuse me. But there are still, right, despite that, barriers and inequities in access to contraceptives and to counseling. So most contraceptives used by women require prescription. So there's medical gatekeeping involved. It's, I'm going to make the pitch right now, the pill should be over the counter, at least that one. So you need access to a provider with authority to prescribe. Most states authorize more than MDs to have that authority. So advanced practice registered nurses have the authority to prescribe in most states, but the range of providers with authority to prescribe, they're not evenly distributed around states or within states. So there are some areas in which you can't find a provider to issue that prescription. And then in addition, experience with discrimination in healthcare deters people from seeking the most protective forms of contraception. So women of color who've experienced that discrimination are more likely to use barrier methods, for example, and they experience higher rates of unintended pregnancy as a result. And then certainly we've all heard about how the domestic gag rule issued during the Trump administration cut Title X planning networks' patient capacity. It cut it by nearly half, which means it also cut access to contraceptive coverage within those clinics as well. And then there's the cost. So even if you have private insurance, you might not have an employer or other means to seek coverage for contraception, in large part because of the very broad religious exemptions that were passed, not just during the Trump administration, but largely during the Trump administration. And then the last thing I'll say is that this is on a slightly different point, is that all the abortion restrictions that are being passed, and this ties to something that Mary said, they're also being used as templates for restricting access to gender affirming care. So the laws like SB 8 or the law that's at issue in the Dobbs case from Mississippi are also threats to people who are LGBTQ as well. So the access to gender affirming care and puberty blockers right now, I think, are just the start as these laws roll into place for abortion restriction. So I'll stop there.
Thank you, Professor. Professor Goodwin.
Thank you so much for doing this for us. And it's such a pleasure to be with my colleagues this evening as we unpack what's ahead. So it's important to understand the Texas law, not in isolation, but in conversation with other restrictions and prohibitions taking place in our country, such as voter suppression, as also coming out of the state of Texas and across the country in the same states where we see very active efforts to undermine access to abortion rights. And so we have to understand this as a very well-funded, very well-oiled movement that's not the brilliance of the Texas legislature alone, but by forces that have spent quite a bit of resources providing the intellectual heft to figure out the ways to undermine Roe, perhaps not by one strike, but by 1,000 strikes. So understanding this as not a sprint, but a marathon is critically important. So I'm so glad that Mary began the conversation. And so I want to connect what Mary was saying with also with what we've just heard from Lisa, from Professor Ikemoto, about this playbook and about the intersections, because when one looks at the Texas law, what you can't miss, and that's spoken to in Justice Sotomayor's dissent in the shadow docket case that we get from the Supreme Court, as the Supreme Court is appealed to issue an injunction against this law going into effect. The court decides not to do so in what is described as a shadow docket response, which is that there is an unassigned order from the court. We don't know who's actually speaking to this. But as Justice Sotomayor spoke to the bounty that we see in this particular law, and I couldn't help but think, as I was reviewing the law itself, that this struck me as a part and parcel of what we saw from U.S. fugitive slave laws, U.S. Fugitive Slave Act, where individuals were incentivized to go after, to surveil, to hunt down, and to capture and intervene against those individuals who would seek to use, obtain, be a part of their civil liberties and civil rights to just simply be free. And so much of that we see in parallel, at least I do, with this case. But I also see something else that I think is critically important before I just go through a few quick points and we further open it up with Dr. Harkin. And that is the chilling effect that we see from this law. So if we were to have this law in conversation with other laws in the Supreme Court, what the Supreme Court has done is send a signal to any other state that is looking to undermine and gut Roe v. Wade and is figuring out, well, which way do we go about doing that? Do we do it the Texas way with a 6-week abortion ban that provides no options in case of rape or incest? Or do it the Mississippi way, a 15-week abortion ban that provides no exceptions for rape or incest? Or do we try some other method? Well, the Supreme Court sent a signal, the Texas method actually works for us. But there's something incredibly dangerous about that. And one of the things that's horrifically dangerous about this is not only the kind of spying that it legitimizes of neighbor to neighbor, and it's not only the legitimization of the kind of harassment that's attendant to that, because let's be clear, every day in the United States, there's harassment at abortion clinics all across the country, but it has this chilling effect about who can you talk to? So let's imagine the 14-year-old girl who's been raped, who wants to talk to her mother or wants to talk to her aunt, and now understands that there is a state law that could get her mother in trouble if she talks to her mother about it, if she talks to her aunt about it. And that is so horrific. And in my mind, it reminds me of domestic violence. Is sort of establishing that same kind of culture of fear. And it's a kind of culture of fear that we saw centuries ago with fugitive slave laws, where Black people feared walking out in broad daylight because of someone perhaps mistaking them or snatching them as they seek to exercise freedom. And so very quickly, some of these other kinds of laws that we see across the country and in Texas, physician and hospital requirements, 38 states requiring abortion to be performed by a licensed physician, and 19 states require an abortion to be performed in a hospital after a specified point in the pregnancy. There are gestational limits, such as what we see with the Texas law and Mississippi law. There are 43 states that prohibit abortion after a specified point in the pregnancy. There are public funding restrictions. 16 states use their own fund to pay for all or most medically necessary abortions, but many others do not. We see bans on private insurance companies being able to underwrite abortions. We see a variety of refusals. We see state mandated counseling, treating women as if they have no knowledge about what is right for them in their reproductive health. And we have parental involvement laws, and there's so much more. We'll get to those, I'm sure, later. But there are myriad laws beyond this Texas law for which all of our viewers should be concerned.
And we'll talk about some of them. Thank you, Professor Goodwin. Dr. Harkin.
Thank you so much for having me speak. I'm Dr. Tabitha Harkin, and I'm a professor of obstetrics and gynecology. And I'm going to be addressing this from a little bit different of a lens. I'm going to be looking at maternal morbidity and mortality. I'm a subspecialty trained and complex family planning physician, and I've done research in 2 countries that had recently legalized abortion. Both countries made abortion legal because when women in their country did not have access to safe legal abortion, they found that women would attempt abortions anyway. And instead of undergoing what is really normally an incredibly safe, low-risk procedure in the first trimester by trained professionals, they would become more desperate and isolated, and they would turn to untrained people, which is what we're going to see in Texas. They would turn to people, and they wouldn't know whether or not those people knew what they were doing. Those people could charge them an arm or a leg to pay for their silence, and they would undergo whatever procedure, painful or not, under sterile conditions or not, because they had no other alternative. And others who were too scared to tell anybody about their pregnancy or just couldn't find anybody to help them would attempt even riskier home remedies. And so women all over the world, all through history, have been known to drink toxic substances, bleach, turpentine, or just as risky, they'd insert herbs or sticks into their body, hoping that something would make them start bleeding and passing the pregnancy. And most of the time, however, these methods never worked, and they only made them very, very sick, and not infrequently, they made them die. And the scenarios that I saw in the two countries where I worked were not unique. The World Health Organization has done 3 really elegant studies that prove that the legal status of abortion does not determine how often women try to have abortions. Making abortion illegal does not increase women's access to effective contraception. Making abortion illegal does not improve knowledge and sex education. It does not decrease the unintended pregnancy rate, and it does not decrease the number of women seeking abortions. They just don't seek them on the up and up. The legal status of abortion only affects its safety. And prior to Roe v. Wade in the United States, when abortion was legal, women resorted to undergoing procedures by untrained people or using home remedies all the time and dying. And Dr. Carol Joffe, in her book, Doctors of Conscience, quoted a resident doctor in the New York City hospital who was working during the 1960s and who described what she called the Monday morning abortion lineup. Women would get their paychecks on Friday, and that night they would spend their money on the abortion. And Saturday they would start being sick, and they would drift in on Sunday or Sunday evening, either hemorrhaging or septic, and they would be lined up outside the operating room to be cleaned out Monday morning. There was a lineup of women on stretchers outside the operating room. So you knew if you were the intern or resident, when you came in on Monday morning, that is the first thing you were going to do. So making abortion illegal, which is essentially what this law does, is so detrimental to women's health that over the last 20 years, country after country globally has decreased restrictions to abortion. 30 countries have made abortion laws more liberal and watched a significant decrease in maternal morbidity and mortality. And in that same time frame, only 2 countries have made their laws more restrictive, Nicaragua and the United States. By making abortion illegal, we will take an incredibly low risk, safe, simple procedure that's done in the first trimester by medical professionals, and instead we'll be making women resort to word of mouth to try to find somebody with the skills who could help them, which is what Dr. Goodwin mentioned about this culture of fear. Women are going to start searching online for remedies. They already have in Texas as soon as all the clinics stopped because of the gag rule. They will not find anything and get further and further along in their pregnancy and become more and more desperate until they try something that's now much more dangerous. We've seen this pattern over and over again. And then what happens to the women who continue their pregnancies, who are denied a wanted abortion and don't attempt a self-induced abortion? There's a beautiful study, the Turnaway study by I'm blanking on her name, but that they followed women for 5 years after they were turned away from an abortion, and they found that they were 4 times more likely to be living below the federal poverty line. They had increased anxiety and decreased self-esteem within 5 years, and they had a higher chance of staying with abusive partners. And that book and study is by Diana Green Foster. So this bill just hurts women and families and further increases the stigma of abortion. And rich women will have the money to travel and pay for safe abortions as they always have. And poor women will be harmed. And unfortunately, too many of them are going to start dying. Thank you.
Thank you, Dr. Harkin. I want to jump over into the Q&A and first clarify something. Dr. Dylan Hanami made reference to a point that Professor Ikemoto made about Black patients seeking abortion care. Dr. Hanami's question, I think, questions whether or not Black patients are in fact more likely to seek abortion care. I don't think that was what you said, Professor. Do you want to clarify that the statistic that you threw out?
So I didn't throw out a specific number, but it's pretty well documented that it's Black women disproportionately who seek abortions.
So I can speak to that as well. Black women have a much higher rate of abortion. Overall, the majority of abortions in the United States, well, white women account for the highest chunk of people who have abortions in the United States, but Black women have the highest rate of abortions.
And then also, I could jump back to something else that Professor Ikemoto spoke to, because you also addressed the fact that African-American women are less likely to get the most protective forms of contraception. So in which case, if you're not getting the pill and you have an unplanned pregnancy, choices may be limited. Victoria in the chat has asked about the bounty hunter provisions. And I have to say, I mean, this is really in an environment and a culture and a time where teachers, you know, some of us talked about this, teachers aren't allowed to ask students if they're vaccinated and are they wearing masks. And, you know, there are all of these purported privacy protections, yet and still, Texas has deputized people. I mean, I could put it in a more academic way, but just to get in people's business. So how antithetical to everything else in the culture is this? And why, and I'll toss this to the two law professors, the Texas legislature did this on purpose. I mean, they thought that they were evading review. And when you read, just as Professor Goodwin put it, the shadow decision, I mean, essentially the court's logic is, we don't know if anybody's ever going to try to enforce this. This appellant's not going to do it and the state can't do it. So we don't really know what this is about. I mean, it's a bit disingenuous.
Tanya, I would love to start there and then turn it over to my colleagues to further respond. One can't take seriously then the opinion that we don't know who wrote it, right? This idea that who will actually try to do anything when in fact, right at that very time, there were organizations that were setting up websites so that people would be able to spy on their neighbors and to be able to list names of people that they believe were aiding and abetting in a person being able to terminate a pregnancy. That was already beginning. There was a thread on Reddit that had already started in that way. And so this was already taking place. But to your point, how ironic it is in a place like Texas, where in fact individuals have been able to protest against getting vaccinated with great sympathy from the legislature and from the governor there, wearing masks, et cetera. And so this very idea, though, that someone else's civil liberties and civil rights and personal autonomy doesn't matter within the reproductive space, but your autonomy does matter with regard to wearing a mask, really points out the hypocrisy behind the kind of legislating that we see within this space. But I think it's also something else that's important to underscore, which is that there has been a control of the narrative and the language that's used within these particular spaces. And so part of that control, if you think about it from a health perspective, is that a person is 14 times more likely to die by carrying a pregnancy to term. That's unrefuted medical science. This we know. But what's also interesting is this kind of backdrop that paints terminating a pregnancy as the most illogical thing that a person could consider, as the most dangerous thing that a person could consider. And I think bringing that up in this conversation is really important, as well as what the law itself describes itself as being, which is a heartbeat legislation. And I'm concerned that journalists use that term too, because there is no heart that is established yet. We are talking about an embryo. So there is a way in which there's been a powerful rhetoric from the legislature, these legislatures passing these kinds of laws that's very inexact.
Professor Ikemoto, were you about to jump in?
You're on
Sorry, I
mute.
was thinking probably Mary's probably the best suited to explain sort of the bounty aspect of it. I could do it, but I think she'd be better at it.
Thank you.
Professor
Well, I think that one thing to understand about the bounty provision of this is what it's an alternative to, right? So the people who are in the abolitionist movement have historically argued that you should not follow the law whether the law is Roe, whether the law is saying you can't trespass at abortion clinics, or you can't violate abortion clinics, or you can't murder abortion providers, because man's law is second to God's law. And so often when you're thinking about bounty provisions, what you're thinking about is the state looking at a group of people that it thinks is going to use vigilantism, not in service of the law, but in violent ways, right? And so this is, I think, a way to say to people who want to take the law into their own hands, you can do that, and you can get paid to do that, but please don't go out and kill people and violate the law, because we're trying to look like a respectable legal movement that's going to reverse Roe v. Wade. So it's taking what would be a liability for the movement, which is, I think, intent on convincing the Supreme Court to reverse Roe, will have to go and make its case in purple states like Florida that an abortion ban is a good idea, and wants to do that with clean hands, right? And not with the headlines being dominated by people committing acts of violence. But a bounty provision in the context of Texas is a moderate, that's the most probably mind-blowing thing here, but this law was criticized by a lot of people who are opposed to abortion as being too weak, because it didn't, for example, involve the death penalty, which is the movement, the abolitionist movement in Texas's bill of choice. It was literally a bill that would subject both doctors and women to the death penalty for having abortions early in pregnancy. And so when you're thinking of SB 8, you have to think about it on the continuum of what the movement says it wants, which is often for the consumption of judges and politicians at the national level, and what rank and file people actually want. That may not always be executing people, but there's a group of people who do want that, and those people are often very committed and a potential liability from a social movement standpoint. So bounties in the grand scheme of things are not even extreme if you are kind of within the thinking of these movements. And they're designed, I think, as a way for the state of Texas to turn these bounty hunters from people who would be undermining their ability to get what they want into a way of enforcing the law. Because otherwise, as I mentioned, I don't see how you can enforce a law like this if you're the government of Texas in a big, complex state where medication abortion is not hard to get. You have your parent, your sibling, your friend, your pastor, literally anyone spying on you, and you have people camped out outside abortion clinics. The state stands a much better chance of actually being able to enforce these laws. And that's really important to this scheme too.
So let me ask you a follow-up to that, because you spoke to the abolitionists, as they call themselves, preferred death penalty bill, and their work on SB 8 in terms of penalizing patients and doctors. Any discussion in the legislature about men who impregnate women? Any penalty, any increased risk for someone who impregnates a woman and takes off?
No, I mean, the only thing I've heard, Greg Abbott has announced that he's going to eliminate rape. So that was
right.
Pretty exciting news, because, most people had thought of that already, but now the good news is there won't be any rape in the state of no. I mean, but essentially there is no rape or incest exception. The only thing that sort of approaches a rape or incest exception is that this cannot sue to get damages from the doctor or the aiders or abettors. Now, of course, in practice, that doesn't mean anything, because as many people know, victims of sexual assault or incest don't often report it. And if they do, don't often get convictions. So for all intents and purposes, this would more amount to, if you've been a victim of sexual assault, you have to get hauled into court and prove it in a county that's going to be very hostile to you, while technically you can't be punished. But no, I mean, generally the spirit of the law is much more the spirit of the idea that men, gender men in particular, have been victims of discrimination because they're not enfranchised to make decisions about abortion. It's not particularly a law that's designed to make cisgender men take responsibility for pregnancies. That's not really the spirit of the law.
Yeah, as Professor Goodwin pointed out, the hypocrisy of these different measures is lost on no one. Dr. Harkin, when you think about the impact on low-income women, patients who now have to fear having the police call on them, I mean, we're talking about the same constituency, many of the women who already live in fear of being overregulated, followed, or hyper-policed. What impact do you think this is going to have on the health and morbidity rates, to put a more precise pin on it, of those women?
It's gonna be horrible, because those women are, we know that abortion patients are predominantly poor, that 75% of them are poor or low income. And that's because they don't have good health insurance, they don't have good access to contraception. And they also have less means to care for another child because we don't have great social systems to care for those children. And because we don't have mandatory parental support or things like that. That would be very nice to have, so that husbands would, or partners would be able to pay for children. This is really going to impact them. There's already a distrust in the medical profession from poor women and women of color, and this is just going to accentuate it. So I fear that this is just going to break things down even more.
Professor Ikemoto, you spoke a bit at the outset about how this legislation is really a template for regulating other types of treatments, gender affirming treatments. Tell us a little bit about that.
And if you think about sort of part of what's, historically what's happened, and historically, I just mean just the past few decades, it's not sort of going back to ancient history, is that healthcare has been now divided up. Right? So there's women's reproductive health care, right, which is now segregated from the rest of healthcare, right? So there's no such thing as comprehensive health care for women in this country because abortion and increasingly contraception, right, have been moved out. And so just when gender affirming care is starting to become normalized, or at least talked about as if it's an acceptable part of comprehensive health care, right? Some states are using abortion-like laws to move it into the segregated space that has been primarily occupied by abortion and other forms of reproductive health care recently. And those laws look very similar to some of the abortion restrictions. So they are going after minors first. So minors' access to gender affirming care and putting age limits on it, which is exactly what happened to abortion.
And it's worth pointing out that some of those bills, some of those proposed bills would also criminalize parents for providing treatments to their parents. So once again, we're seeing a tendency of some legislatures to really intrude in the family relationship in ways that may or may not be novel to them. Professor Ziegler, or actually, let me ask you this, Professor Goodwin, because you made this point in your opening remarks. The Supreme Court, in this shadow decision where they said, oh, we're not sure if anybody's ever going to really enforce it. And oh, this appellant, this respondent has said he has no intention of enforcing it. They now have a template. They now have a playbook. Is there nothing to do for those who would advance the cause of reproductive justice except wait it out and find a test case and wait for someone to be sued because someone thinks that she's trying to terminate a pregnancy? What's the legal strategy?
So there are paradigms that we can learn from in the past. Again, this is history revisited. And so we can see the kind of arc of history leading to Jim Crow and civil rights organizations offering up individuals in the movement to become the face of litigation at enormous risks to themselves. I mean, so let's be clear about an aspect of our history that we don't concentrate significantly on, which is that the promise of the Constitution became real through the efforts that were leveraged in the 40s, 50s, and 60s. And those efforts weren't, funded by major organizations. They weren't funded by benevolent, very wealthy people. Those efforts to move Brown v. Board of Education along, to do the work that Rosa Parks did, et cetera, was the work of organizing at local levels. And so I just lay out part of that history because we've seen it revisited in the shaping of these laws And what's also interesting is that we've also seen the co-optation of the language of the civil rights movement by those who are opposed to reproductive health, rights, and justice. But I think that what we'll see, we don't have to wait. I mean, there can be, just like in the era of Jim Crow and the civil rights movement, the kind of organizing that leads to the kind of litigation that might make its way into court where individuals can defend the constitutional right to be able to terminate a pregnancy. But let's be clear, that's at significant cost. And when you think about some of the legislation that's been part of the toolkit, the playbook of the anti-abortion movement, some of it has been to push organizations and movements to spend a lot of money to just keep afloat, or maybe even to lose, to keep them in a bit of a disarray. I mean, that is part of what we see. So in Texas, just in the recent weeks since this law has gone into effect, we see the scrambling. We see that people are not able, who otherwise would be providing care to patients, are not able to provide care to patients and things like that. So it's a longer way of addressing your question, but I think that we can learn a lot from the civil rights movement going forward in instances like this.
Dr. Harkin, Kathy Jensen has a question that I think is well suited for you. How will they verify the 6-week cutoff? Most of us know that that's a time when most women don't even know they're pregnant. Mm-hmm. So how are they going to verify it? Is it going to be a state-approved doctor, who says 6 weeks and 2 days? Is it another doctor that says, no, she's only 5 weeks? What's the process going to look like from a medical patient treatment standpoint?
I don't think that we know that. Normally, in order to verify the gestational age, you go by the woman's last menstrual period, which is her memory of it, and an early ultrasound. And so people who put up these lawsuits will have no idea how far along she is. And so then they'll still be able to start suing people and making accusations, which will drag them down. It'll be very hard to know.
And another question in the chat, it was part of a longer question. Someone wanted to know who pays the $10,000. It's the patient. Do I have that right? Professor Ziegler, Professor Goodwin, Professor Ikamoto?
It's the person being sued. So it's either the doctor or the aidor or abettor, right? So it's designed to discourage, people. At the moment, what's happening is no one's performing abortions because they have to pay both. It's worth saying not only the $10,000, and it could be a minimum of $10,000, and attorney's fees, right?
Attorney's fees.
Exactly. Right. So it's going to be the person who's found liable, quote unquote. So the person doing the aiding, abetting, or the doctor.
There was another great question in the chat related to that point. So what happens if you're sued by someone who says that you either tried to get an abortion or you aided and abetted? You win. I mean, they lose. They sue you for no reason. You win. Can you sue them back? Can the patient or the alleged aider and abettor sue them for bringing the lawsuit in the first place? Is there any provision for like a sanction or some recovery for somebody suing you for no good faith basis?
I mean, my understanding is that under Texas law, if the suit is really, really frivolous, there could still be sanctions. The law makes it virtually impossible for you, if you're the aid or abettor or a provider, to get attorney's fees, though. You pretty much, to be the quote unquote, the prevailing party under the statute, you pretty much have to run the table in a way that is, in the sense of like, none of your claims can be moot, none of your claims can be rejected, and even then you might not get attorney's fees. So there's really very little incentive for you to counter. So it's financially very difficult for you to do much of anything with this law, and it's designed that way. I mean, the people who wrote it made very clear that that was the end goal. So obviously, you can challenge the constitutionality of the law as applied to you, which is, of course, probably one of the more promising ways you could question the validity of this law. But in terms of just a countersuit for a frivolous lawsuit, that's hard to do given the way the statute's designed.
Yeah, hard to do in almost any circumstance generally. Professor Ikamoto, we've seen, I don't want to overstate it, we've seen some large companies, Uber, I believe, and others say that they'll indemnify drivers who are sued for aiding and abetting. what sort of, or rather, do you think that these sorts of statements, like there's a lot of public opposition to this bill in Texas, is that small comfort to low-income patients? I mean, do you think that low-income women who've had a hard time getting access in the first place, do they feel like they've got some allies somewhere out there in the ether, or are these gestures really a little moment to them?
So I think maybe it's moral support. It doesn't do anything directly for the women who need abortions now. I think the hope of that kind of action, assuming it expands and it expands substantially, is that it'll make those who are not the abolitionists in Texas, and there's the public survey showed that there's a substantial percentage of people who live in Texas who want to expand access to abortion, who want to get rid of at least some of the restrictions that exist. And there are over 24 existing laws that restrict abortion access in Texas. So, but it will maybe prompt those people to sort of, join up with these big corporate entities and call for a change and maybe a repeal of some of these laws. But there's no direct remedy in it for it or direct support for people who are stuck in the very near future.
And I wonder if it would be okay, Tanya, to actually speak to something else that connects what Dr. Harkin and Professor Ikimoto were talking about in terms of thinking about what this means for Black and brown women in Texas and maternal mortality. So in the US, Black women suffer a maternal mortality rate that's 3.5 times that of white women. But that's not all. So the US ranks between 51st and 55th in the world in terms of maternal mortality, meaning we are at the bottom of all peer nations and even beyond the bottom of non-peer nations. And Texas and Louisiana are considered the deadliest places in the developed world to be pregnant. So that's pre-existing SB 8. And so when you ask this question about what does this mean in terms of options and health of poor women and poor women of color, over time, people have said, well, there's just a lot of oversensitivity, that there's a lot of hyperbole, right? That there is hysteria coming from women as they describe what's happening here. But it's hard not to see this as a death sentence for so many women who are already suffering. And it's not Dr. Ikimoto's website, my website, or that of Dr. Ziegler's or that of Dr. Harkin's that says that. Right now, people who are viewing can go to the Central Intelligence Agency website, the US CIA website, and actually see how deadly it is to be pregnant in the United States. And then you can see the data that comes out of Texas and their own health departments that describe the maternal mortality rates by race in that state. And so it's hard to divorce that, and we shouldn't divorce that from what we see in SB 8 and the anti-abortion movement in states where those maternal mortality rates are already so high amongst people who are coerced and forced to carry pregnancies to term, and even those who want to carry pregnancies to term.
That kind of dovetails, I think, Professor Ziegler, if you wouldn't mind speaking to this, to a point you made, right? Because you said that this bill, SB 8, really signals a shift in strategy of the anti-abortion movement. I mean, once upon a time, it was about, to paraphrase, maybe more emphasis on women. We care about women, we care about babies, we care about families, we want to help you, the fetus is viable. Now the language is, we're coming after you, we're going to find you, we're going to sue you.
Yeah.
So if that's the strategy, and if that's the template going forward for other bills on this issue, is it just a wait and see approach, while people calibrate and look for the right case? Because there's no longer even kind of an ostensible, it's not even sort of ostensibly about looking after women. It's really about punishing them. It's really kind of a shift in tone.
Yeah, I think part of what you're seeing is a fragmenting of the GOP and a fragmenting of the right to life movement, right? So The national right to life movement is the one that forged the, abortion is bad for cis women and trans men. Like that was the messaging. And that came directly from Planned Parenthood versus Casey, because Casey, saved the idea of a right to choose abortion in part because of the idea that that women relied on abortion to achieve more equal citizenship, right? Whether that was taking advantage of career opportunities or educational opportunities. So some of the more sophisticated DC-based anti-abortion groups looked at that and said, if we can show that abortion does not actually help women become more equal and is in fact bad for women, then we can say there's no conflict anymore. You can get rid of abortion rights and everybody wins. That was the strategy. That had been the DC-based organizations, which have a lot of money and a lot of very smart people and a lot of strategy, had been driving the approach for a while. In the Trump era, starting in 2016, that began to break apart. So a lot of local Republicans began recognizing that what was good at the national strategy level when it came to reversing Roe or electing Republicans to the Senate or to the White House was not necessarily good in East Texas, right? That you could go a lot further and do things that were a lot more radical by energizing your base. And if that did damage to the national movement or to specific petitions, you didn't really care because you won. And so there, I think, both a sense that Trump, that the way you is by pumping up the base, even if you're alienating the average voter, much less a pro-choice voter, but just a voter doesn't know what to think about abortion, and a sense that you're shrinking the electorate anyway, so you don't need to be appealing to the average voter, and a sense that ultimately all abortion politics are local. I think there's a really profound reflection of that in the way SB 8 has worked and the way a lot of these bills have worked. So the messaging is increasingly contradictory. So even at the US Supreme Court right now, in the Dobbs case, you see lots of briefs saying, hey, you know what, let's overrule Roe because it's better for democracy. Let's restore this to the state. It's bad to have the Supreme Court taking this abortion issue away from the people. And then you have lots of other amicus briefs saying, let's take the abortion issue away from the people because the unborn child or fetus is a person under the 14th Amendment and abortion is unconstitutional. And the Supreme Court should intervene to protect that interest, right? So the movement increasingly is not singing the same tune. And that's a reflection of, I think, broader trends you see in conservative movements and GOP politics that ultimately I don't think really help the campaign to reverse Roe. But given how conservative the Supreme Court is, it may not ultimately matter, right, if the movement is speaking contradictory messages. That, I think, at any rate, is the calculation people are making in Texas.
Rowena has asked for a quick primer, a refresher on the current status of abortion laws in California, something that may be relevant given that we're in the middle of a recall election taking place right now. Any of you want to do a quick refresher?
So just very quickly, California has one of the states with the most robust protections for reproductive health rights and justice. Ensconced in the California Constitution is the protection of the right to be able to terminate a pregnancy and also access to reproductive health care, which has also been furthered by legislation in the state of California. But even though California stands out and stands apart as this kind of robust place to be able to protect individuals and their reproductive rights, it's also important to note that there have been efforts to encroach upon that. We have seen coercive sterilization in prisons and jails in California, and this is not something that's just like a eugenics story from the 1920s or 30s, but we're even talking about something more recently within the last 5 to 10 years. And I'll turn it over to Professor Ikemoto, for adding in any more to that, which we've also seen with Catholic hospitals seeking to do alliances with the University of California system.
Sure, I'll add a bit. Just with respect to the first point that Michelle made, I would say that we have an abortion ban from viability. So during the third trimester, with the exceptions for abortions that are necessary to protect the health and life. But before that, we have virtually no regulation of abortion. So there have been several attempts, for example, to try to pass parental consent laws in California. None of those have succeeded either by ballot initiative or by legislative effort. So when Michelle said that California is one of the most protective states, that's in part what she was referring to. California is also one of the first state Supreme Courts to issue a pre-Roe decision, finding a state abortion restriction to be invalid. So our state constitution is more protective than the federal Constitution at this particular point. And then the second point that Michelle raised is that sort of, what's going on in sort of the private sector, and this goes back to the point I made about religious exemptions, is that we have very broad federal legislation, which allows both individual providers and institutional providers to refuse to provide healthcare services, and they turn out, not surprisingly, to be reproductive healthcare services based on religious or moral beliefs. And so hospitals, and it's the Catholic hospital systems, are subject to a set of rules called the Ethical and Religious Directives for Healthcare Services. Those are promulgated by the U.S. Conference of Catholic Bishops. And that means that if you go to a Catholic hospital, you can't get an abortion, assuming that you need one in a hospital. You might or probably can't get a tubal ligation, depending on your circumstances. And they are using the ERDs to refuse gender affirming care, such as hysterectomies for transgender men in those hospitals as well. These hospital systems are big. It's 1 out of 6 hospital beds in the United States. And so it's not a discrete impact that this has on the availability of services.
Professor Ziegler, is the removal of, or the non-inclusion of a rape incest exception here, was that, in your view, something intended to assuage these so-called abolitionists, or was it a more deliberate legal strategy?
It's actually a mainstream thing. So even people who are not considered extreme within the anti-abortion movement don't support rape and incest exception on the merits. Politicians do, because if you poll people on rape and incest exceptions, most Republicans overwhelmingly support rape and incest exceptions. So they're probably, and if you go through historically, virtually every Republican president, I think to my knowledge, including Donald Trump, supported a rape and incest exception for precisely that reason. People who are opposed to abortion don't support rape and incest exceptions for reasons that actually make sense, because if you believe that a fetus is a rights holding person, or a rape and incest exception is incoherent. And so generally that means, it's one of the reasons it's sort of ridiculous to argue that if we reverse Roe, this debate will sort of magically disappear and everyone will compromise. If the position of one movement is that a fetus or an unborn child is a rights holding person, you can't have any abortion unless there is a threat to that another person's life, or it's inconsistent with your principles. So in recent years, really since 2019, you've seen states start to ditch the rape or incest exception. It hasn't happened across the board. Like, for example, South Carolina passed a heartbeat bill with a rape and incest exception. But increasingly, I think what you're seeing is that people in the anti-abortion movement know that they have a 6-3 majority on the Supreme Court. And increasingly, then you're seeing laws that reflect what lawmakers would actually like the law to look like, rather than laws that reflect what they believe are strategic imperatives, right? And so you have very different kinds of laws emerging from states 15 years ago, because it was all about winning in the Supreme Court. Now the supposition is that anything will work in this Supreme Court, so the movement might as well ask for what it wants, and what it wants is laws without rape or incest exceptions. So we should expect that to continue and probably accelerate if Roe is gone, and even if it isn't.
Professor Goodwin, Stephen White has a question in the chat. What are the limits of vigilante enforcement of laws? Is there a precedent outside the Jim Crow era? And I'll amend his question, outside the Jim Crow era and other than the stand your ground in Florida era.
Right. Well, if we're to look at what is Supreme Court precedent in this domain, many law students, let's say, are familiar, and people in the public are familiar with Dred Scott. It's an opinion that was penned by Chief Justice Roger Taney, where he said that Black people were never supposed to have the rights, the personhood that white people have. But that's not the only notorious case that he penned, his name to, or that he participated in. There's also a case that upheld the fugitive slave laws, the Prigg case, a case that involved Pennsylvania enacting a law that accorded freedom to Black people who fled to that state or who were born in that state and were there for a particular period of time. And upholding the fugitive slave law in its full breadth, the Pennsylvania law was struck down. So when we think about, as a matter of precedent, what happened to be these kind of limitations on this kind of bounty hunting, we actually have it written into law through Supreme Court precedent that it's quite fine. But it is inconsistent and antithetical to a well-ordered society, for sure, that there would be people who would be hunting other people down and interfering with people's personal relationships. So I'd like to introduce into the conversation something that we haven't talked about, but that I've been writing about, and that is the First Amendment aspects of this. So while we've been thinking about it in one frame, another frame that we could think about it, and then again, you sort of thinking through this through Jim Crow, was the use of the First Amendment to defend against and fight against the encroachments by the state. So we think about cases where there were Southern lawmakers that wanted to have the identities and the names and know people who were associating with the NAACP. The way to fight back against that was actually to use the tools of the First Amendment. And it was done successfully. And so what we might do is sort of think about how to move outside of what is obvious in this space to other spaces, right? Thinking about the right to be able to associate, the right to be able to assemble as being foundational in the Constitution, part of the First Amendment.
Not unlike what the strategy in passing the Civil Rights Act. I mean, one might say that there are commerce implications when you start bringing lawsuits against people for driving people on public roads. Dr. Harkin, you spend a lot of time with students, with patients, in providing access. We've talked about the likely impacts of SB 8 on poor women and disadvantaged women, but don't you think that this is going to have perhaps a chilling effect on, as one of our participants put it in the chat, tech companies, for instance, who are bringing high-income, high-skilled women to Texas? Is there going to be, does Texas look a lot less business-friendly than it did, say, a year ago when everybody was moving there from California?
Yeah, I hope so. I really, really hope so. It's hard to imagine professional women wanting to move there now. At the same time, there are plenty of professional women who consider themselves anti-choice, and as are their families. So I don't know what that would look like, but yeah.
Do any of you think that this bill kind of is going to do something to move? Let me phrase it a little differently. I think that there's a constituency of self-identified conservative women in the country who would identify themselves as, pro-life, anti-abortion, but for whom even a bill like this may go too far because of these bounty provisions. Do you think that this is likely to incite some of the kind of internal civil war in the GOP that Professor Ziegler talked about? Any of you?
Yeah, it's happening already, right? So one of the clearest signs, initially when SB 8, when the Supreme Court declined to intervene, a bunch of Republican governors who were all jockeying to run for president in 2024 if Donald Trump doesn't, all announced that they were going to do it too. You fast forward a week and Ron DeSantis has done some internal polling on this and talked to some Republican women, and then his spokesperson announces that he isn't in favor of turning neighbors against one another. Notice he's not saying he's not in favor of banning abortion. He's saying he is in favor of that, but the bounty piece of it is creeping people out in ways that I don't think anybody foresaw within the movement in Texas or nationally. And so I think that the bounty provision is causing debates because it's creepy, because it's a bounty provision, which isn't necessarily appealing to conservative women either. And because a lot of people on the anti-abortion side don't think this is necessary, right? They think the Supreme Court is going to overrule Roe and they can just use the state to criminally punish people when they want to, and that this is just bad PR that's the result of impatience, and that if the movement just holds on a little longer, they have a conservative Supreme Court that's going to give them what they want anyway. So this is absolutely sparking that kind of debate, and you can see signs of it bubbling to the surface, right? Because the politicians in the national and state GOP are already sometimes retreating from this because the idea of a bounty is unsettling even to people who oppose abortion.
We have about 8 minutes left, and I think I'd maybe like to give you all a final word on what are the next steps and what can be done to help women, because a number of people in the chat have asked about that. I'll start with you, Professor Ikemoto, because your work, you spend so much time focusing on access and mediating disparities. This is going to exacerbate disparities. So what is something that can be done for that constituency of women with whom you work right now? What is something that people can do to help?
I mean, a number of the, people who've been working on this have been sort of preparing for this moment. So some of it's focused on access. And so you locate the clinics at the borders with the states who have them. So Tabitha mentioned earlier, right, that Mexico is going to be a go-to place because of the recent decision by their Supreme Court. New Mexico has actually greater protection for abortion access than California does. That's also a neighboring state of some of this, this cluster of states in the South that have the strictest restrictions. So you have those kinds of moves, and then hopefully continued availability and widespread availability of medication abortion as well. But I think some of the most important efforts are not actually legal efforts. It's about culture change. So instead of thinking about this issue on the defensive, it's about pushing for, making it clear that what's really at stake is it's equality. This is about segregating out and subordinating more than half the population, right? And saying you have fewer rights than the rest of the population. And so bringing that back, as Justice Ginsburg, right, pushed for before she was Justice Ginsburg, right, back when she was an ACLU lawyer, for example. And I think also making a deliberate effort to make it clear that comprehensive healthcare includes the full range of healthcare accesses, healthcare services for everyone, including abortion. So we have to be willing to say comprehensive healthcare includes abortion, contraception, gender-affirming care, and say that over and over and over.
Thank you. Professor Goodwin.
Well, I think one of the critical things that we can do is to make sure that these conversations are adjacent, integrated with thinking about the other ways in which protections, civil liberty and civil right protections have also become vulnerable. So voting rights, critically important. Increasing pathways for women running for office is critically important. Leaning into the judicial space in a way in which Democrats typically have not. It's worth noting that during the Trump administration, President Trump was able to nominate and get through more judges to the federal bench than any other president, save George Washington. It's also worth noting what that meant in terms of race, because as of the year that he left office, not one was an African American that was nominated to the Federal Circuit Courts of Appeal. So I think that there are adjacent conversations that are important to integrate into what comes next in terms of abortion right. But the political process, I think, is a critical aspect of this conversation. Getting folks to run for office, folks getting out there and voting, really important.
Thank you. Professor Ziegler.
I would just underscore what Professor Goodwin said. I think the lesson of history is often that the Supreme Court can't settle this, right? So Harry Blackmun had in his files a poll clipping that said roughly 70-something% of people thought abortion should be a decision between a woman and her doctor, which doesn't really differ that much from what polling would suggest now. And Blackmun thought that if he wrote an opinion that mostly tracked what people believed already, that it would settle the abortion issue. And you can see where we are now. You see plenty of people in the anti-abortion movement suggesting that the Supreme Court can settle the issue by reversing Roe. And the lesson, I think, of what we've seen for the past 5 decades has been that political mobilization really matters. Grassroots protests matter, public interest litigation matters, lobbying matters, making abortion an issue that matters on election day to candidates and voters makes an impact. And so there is no way a court, as much as the court matters, and as much in many instances as I don't think progressives have understood or done enough to deal with the importance of the court could never settle this. And so people who are feeling, I think, disenfranchised by the prospect of the court almost inevitably overturning Roe should realize that the Supreme Court has only been a very small part of the constitutional dialogue about abortion. I wouldn't say a very small part, but it's not a monologue. It's not the Supreme Court talking to us. It's us in engagement with the Supreme Court. That's always been true. And that's how we arrived at a moment where Roe could be reversed. But that lesson can just as easily be applied by progressives. And so I would encourage people not to feel hopeless and to see, in some ways, the overruling of a major Supreme Court decision is often a moment of tremendous political creativity and energy. And often a big Supreme Court win can sometimes be a source of complacency. And so using a potential setback as a boost is something that social movements often do quite well. And I would hope to see done here too.
You think it's inevitable that Roe and then necessarily Casey will be overturned?
I wouldn't say inevitable, but I would say very, very likely. I don't know if it's going to be happening this year, but I would be surprised if it doesn't happen in the next few years.
Dr. Harkin, final words for folks who want to get involved.
Yeah, I cannot improve on what my brilliant colleagues have already said. I think this is a call to action. You have to, particularly if Roe is overturned, people, that's all the more reason to get involved, to vote, to be active, to donate, to speak up locally so that people recognize that this is an important, critical issue and we can't lose ground on it now. So, yeah.
Well, thank you to all of you. Thank you, Professor Goodwin, for putting together this panel, an important conversation at an important time. Certainly, there will be much more to come. Thank you, all of you, for your contributions and for the work that you're doing in the world and for being here tonight. Thanks, everybody, for joining us. Take care and stay safe.
Thank you.
Thank you.
Thanks, everybody.